Station on 3FM 92.7. This bulletin is live from our studio here at Desawe Kanda in Accra and also live around the world on 3news.com. Coming up this evening, lawyers for the NPP's Ashanti Regional Chairman, that is Bernard Ntwibwe-Siakon, left in a dilemma after the Court of Appeal dismissed a second attempt to halt the case against their client at a high court. We have details in a moment. Also coming up, pressure mounts on President John Dramani Mahama to publicly declare his position on the office of the Special Prosecutor by the minority and CSOs. And later in the bulletin, tension is mounting on the Minister for Lands and Natural Resources, Kofi Amabua, to terminate the mining contract awarded to Heath Goldfields to operate the Bogoso Prestia mines. We have details of all these and more coming up for the next 1 hour, including business and sports at the end of the show. Before we bring you these details, let's look at what other stories are making headlines in the news summaries. And Grace Hamwajaman has joined us. Hello, Grace.
Hi, Martin. Let's begin from the education front because the Ghana Education Service, GES, has officially authorized the release of long-awaited funds dedicated to the procurement of perishable food items for senior high and technical schools across the country. The intervention, announced in a formal statement on Tuesday, April 21, is expected to break the logistical deadlock that has recently hampered the feeding component of the free senior high school program. Away from that, the Member of Parliament for Gushegu and Ranking Member on Parliament's Legal Affairs Committee, Hassan Tampuli, has alleged that recent legal and political actions targeting the Office of the Special Prosecutor, OSP, form part of a coordinated effort to weaken the institution after it pursued high-profile prosecutions. Speaking on behalf of the New Patriotic Party minority at a press conference, Hassan Tampuli said the sequence of petitions, parliamentary moves, and court actions against the OSP were not isolated events, but political weapons aimed at dismantling an institution performing its mandate. In a related development, Democracy Hub is calling on President Mahama to take urgent steps demanding the immediate release of the full Constitution Review Committee report, as well as a clear time-bound roadmap for constitutional reforms. Speaking at a press briefing in Accra on Tuesday, April 21, the Director of Policy and Research at Democracy Hub, Ketches Atengbele, said the youth platform on constitutional reform is pushing for transparency and swift implementation of the proposed changes. And before we go, Accra will become the focal point for global and African health experts this week as it hosts the 5th Annual Conference of Pharmacoepidemiology in Africa. The 3-day event, running from April 20 to 22, 2026, is a major initiative focused entirely on making medicine safer for populations across the continent. That's it for the news summaries.
Thank you very much, Grace. Let's settle for the details, and remember to send us your thoughts and comments in the on the stories we have for you on the various social media platforms, Facebook, YouTube, and also on Twitter. We're starting from the courts, and you know that the Ashanti Regional Chairman of the NPP, that is Bernard Ntwibwe-Siakon, has been going to the court. There's been a back and forth on a number of issues, and his lawyers have actually been left in a dilemma as we speak after the Court of Appeal dismissed a second attempt to halt the case against Bernard Ntwibwe-Siakon at the High Court. Chairman Wontumi, who is facing charges of assigning mineral rights for mining on his concession and facilitating illegal mining operations, has been ordered by the High Court to open his defense after the prosecution established a prima facie case against him. The case has been adjourned to the 7th of May as the court proceeds with a case management conference at the High Court, but our man on the beat, Lord Eduasari, who was in court, has been updating us regarding what exactly transpired. He'll join us in a moment to give us an understanding of what to expect. But before that, let's listen to lawyer Andy Apiakubi, who is the legal counsel for Chairman Wontumi. He's been expressing his disappointment at the decision of the court regarding the current situation.
Applied for a stay as a repeat of the earlier one. The court does not agree with us, and the court says that the application for stay is refused, which means that indirectly two options: either repeat it or go back to the instant court to prepare our witness statements and continue the case and see the outcome of the case itself. We will then proceed to the Supreme Court and pursue the matter there. If we decide to go back to the High Court to continue the proceedings, so we do. So the options are open to us.
And you heard the lawyer for Chairman Wontumi, Andy Appiah-Kubi, there. And regarding how the current situation is going, it tells you or gets an idea that it looks as though Bernard Ntwebo-Esiakum is yet to put his statement together, his witness statement together. They were supposed to have filed that much earlier, but they were unable to meet that deadline. And on the back of that, the Deputy Attorney General, Justice Sremsai, Doctor, I should add, was asking the court, or was praying the court, to immediately, on the back of the failure of Chairman Wontumi and his lawyers to file their witness statement, to convict the MPP national regional chairman. But that was put on ice, and as we speak, the lawyers for Chairman Wontumi have been expressing grave disappointment over what they say is the rush by the current administration's the Attorney General to force the hand of the court to take a decision. So it is part of the ongoing issues that have been built against Chairman Wontumi, who is currently facing about 6 different charges, including the fact that he was mining in a forest area without authorization, and also allowing his workers to mine without the right permit or the requisite permit. So a lot of issues are hanging around his neck, and for which reason the Attorney General's office is asking that, since he is unable to put up a proper defense, although he's been given the opportunity to do so, the judge should take the next line of action, which is to formally convict Chairman Wontumi. But that has not happened yet, and we'll get updates of it in the subsequent, hopefully before this bulletin ends, to get an idea of what exactly transpired in court when our court correspondent, Lord Edwasare, joins us in studio. But like we indicated, your thoughts on this particular issue are always welcome. If you go to Facebook and YouTube, you would find, just look for 3FM 92.7, and you can be a part of the conversation, where you can also share your thoughts on this very subject, which has been running for a number of months now. Lord has joined us in studio to understand or unpack what transpired, or what the current situation is regarding Chairman Wontumi. Lord, thank you for joining us in studio. To start with, what were the highlights of today's proceedings when Chairman Wontumi and his lawyers appeared in court?
Right, thank you, Martin. Now, this was born from yesterday. You recall that they were in court and at the High Court, and the presiding judge dismissed their request to halt the proceedings. Now, they indicated that they had escalated the matter to the Court of Appeal, and so the Court of Appeal heard that matter today. Now, the lead counsel for Wontumi, Andy Appiah-Kubi, he made the argument that the order by the High Court to get Wontumi to open his defense, the ruling essentially was prejudicial, indicating that if the court allows the case to continue, it risks unfair trial and injustice for Wontumi and then Akonta Mining being the accused persons in that case. And so he was essentially praying the Court of Appeal to stay proceedings. So essentially it was a repeat application of that stay proceedings application that he had filed at the High Court. Now, Deputy Attorney General, he led a prosecution, or in this instance, the respondent in the case indicated that in as much as it's in law for the applicants to file stay proceedings and all the documentation around it, they have to demonstrate beyond reason why they should be granted. Now, after listening to both arguments from counsel for the prosecution and then the defense, the 3-member panel of justices ruled that the defense, or in this instance, the applicants, meaning Wontumi's lawyers, had not proved, they hadn't demonstrated enough grounds to warrant staying or halting the prosecution or the case at the High Court. They indeed took cognizance of the fact that Wontumi's lawyers have filed an appeal, an interlocutory appeal against the ruling of the High Court regarding that decision for him to open his defense. But be that as may, they indicated that they haven't proved enough to warrant the grant, and so that was dismissed as well. Now, Andy Appiah-Kubi and essentially the defense lawyers were not pleased with the outcome, and they spoke to the media tentatively saying that they have two options which they are going to ponder, and then they'll proceed on with that. Now, what this means, Martin, is that on May 7, when Wontumi and his lawyers are supposed to be back in court at the High Court, they, one, may have to file their defense in the form of filing the names of the witnesses and their addresses and all the other documentation disclosures that they rely on in defending Wontumi, or they will escalate the matter to the Supreme Court, being that the Court of Appeal through their application to stay proceedings away. So what this means is that they'll file another civil proceedings, repeat civil proceedings at the Supreme Court. And if that is granted, then they may have to go back to the High Court and say that, okay, we won here. But if that is dismissed as well, then that would be the case. But I mean, from not to prejudge the entire situation, but when a situation like that goes to the Court of Appeal and it is dismissed, there's a very little chance that the Supreme Court will take that as well. So that's the matter regarding the Chairman Wontumi case.
So just so, I mean, our listeners and then those who are watching us on social media, just so then they are all on the same page as us, the lawyers for Chairman Wontumi, or Chairman Wontumi for that matter, is asking the court to do what exactly? Why did they go to the appeals court, the Court of Appeal? Right,
so two applications, right? They filed what they call the interlocutory appeal. Now, this was essentially challenging the High Court's decision. Now, when the prosecution closed the case last month, the High Court held that, or they found that a submission, the prima facie had been established against Wontumi, meaning that from the prosecution's case, the prosecution had been able to prove that Wontumi has a cause or a case to answer. Now, Wontumi at the High Court has been charged with illegal mining charges, being that he has given permission or assigned mineral rights to certain persons to mine at his concession, and then facilitating illegal mining at Samaraboy in the Western region. Now, the prosecution closing their case established that there were enough grounds for which reason he ought to open his defense and answer for it. Now, lawyers of Wontumi indicate that from the evidence and the prosecution's witnesses, they hadn't proved enough to warrant Wontumi opening his defense. So in their argument, they were praying that the court ought to have ruled in their favor as far as the submission of no case is concerned. Now, if they had won the submission of no case, it would have meant that he would be discharged and mean that he'll go scot-free as far as this case is concerned. But that did not happen, and so aggrieved as they were, they went to the Court of Appeal to challenge the High Court's decision, meaning that they are hoping that the Court of Appeal will quash the decision by the High Court. Now, filing this does not necessarily mean that the case at the High Court will stop. So they filed an application to get the court to pause the case at the High Court whilst the Court of Appeal hears and determines their challenge of the High Court's decision. So this was what was dismissed by the High Court, and then they went again to the Court of Appeal to get them to halt the trial, which did not happen. And so this is where we are.
Okay. So on the 7th of May, they are expected, in this context, we are talking about the lawyers for Chairman Wontumi.
Indeed.
And Wontumi himself. They are expected to be in court on the 7th of May to now do what? File their statement of case, or at least give the list of people they believe will be witnesses to testify on behalf of Chairman Wontumi.
Indeed. So we call that the case management conference. And during that stage, that is when the defense will indicate that, okay, we are calling 3 witnesses or we are calling 6 witnesses to speak for Wontumi, and then all the documentation that they feel that it will aid their cause to make sure that Wontumi is not convicted of these charges. Now, these documents are supposed to have been filed before 7th of May. The court ordered that they should have made these filings by 5th of May, and then they are back in court on 7th May. So when they come on 7th May, they just tell the court that, okay, we have filed our disclosures. These are the number of people who are going to serve as witnesses for Wontumi. These are their locations where they can be found and whatnot. And we believe that when they are called upon, they'll come to court to come and testify on behalf of Chairman Wontumi.
Okay. So 7th of May is just a few days away. We just have to keep our fingers crossed and see how it goes. Thank you very much, Lord Asiedu-Dartey, for updating us on the case involving Chairman Wontumi, who is the Ashanti Regional Chair of the New Patriotic Party. About 6 different charges have been slapped on him, and so we wait to see what his defense will be like in the coming days. You're still listening to 3FM 92.7. Stay with us. When we return from this quick break, we'll be taking you back to the court, where this time around you know that the OSP has been in court, or issues surrounding the powers of the OSP has been in court. One major individual who is in the heart of the storm, that is Abdul Hamid, who is former CEO of the National Petroleum Authority, is expected, in fact, was in court and was asking that the court dismiss the trial because he believes, or their lawyers believe, that the special prosecutor does not even have the gravitas to bring the case to court in the first place. Details of all of that and more in a jiffy. Still listening to 3FM 92.7. This is Hot Edition. We are going back to the court now, and the High Court has adjourned the hearing of the case against former National Petroleum Authority CEO Dr. Mustafa Abdul Hamid and 7 others, pending the determination of a stay of execution application that was filed by lawyers of the the Office of the Special Prosecutor, challenging orders barring their prosecutorial powers. Dr. Abdul Hamid and the 7 other accused persons, have been charged with multiple offenses, including stealing, extortion, and money laundering. Lord Asiedu-Dartey is still with us in studio to try and unpack what exactly this means. So, Lord, even before we come to the substantive subject of Mustafa Hamid, we know that the OSP also has a case that involves him, but he didn't take it to court. And people, or some private citizens, are challenging the authority of the special prosecutor, including the fact that the Attorney General seemed to have joined the case and have expressed interest and actually have agreed to the High Court ruling, which says that the OSP does not have the power to prosecute. So it's on the back of that Mustafa Hamid is saying that, well, if the man doesn't have the power to prosecute, he cannot then bring me to court in the first place. Is that a fair narration of where we currently are regarding Mustafa Hamid and the OSP?
Right, Martin. So like you indicated, this is born from the High Court ruling at the General Jurisdiction 10, presided over by Justice Asiedu-Dartey. Now, in that OSP case against some persons regarding the rice scandal. Now, the accused persons in the matter sought to challenge the OSP's prosecutorial powers and went to court, indicating that the OSP from the Constitution and indeed the OSP's Act cannot prosecute without obtaining authorization from the Attorney General. Now, the court ruled in that matter that indeed the OSP has not got the prosecutorial powers, and so once they hadn't been able to prove that they hadn't received the authorization regarding that rice scandal, they need to stop all the prosecution and indeed hand over every other prosecution that they are going ahead with to the Attorney General. Now, what this meant was that although it was binding on that case, which is the rice scandal case, the cascading effect is that every other case that the special prosecutor is prosecuting may suffer from this ruling, and that's what we saw today regarding the Mustafa Hamid case. So Mustafa Hamid lawyers came to the courts indicating that, okay, this is what happened just about a week ago in another high court. Now, with this in mind, we do not think that the OSP should continue to prosecute this matter because they haven't even finished dealing with this. Now, at that point, the lawyers of the Office of the Special Prosecutor, led by Principal Prosecutor Adelaide Kubriwood, indicated that this is the case, but then again, they have filed a notice of appeal and then a stay of execution application challenging that High Court order. And so they indeed wanted the courts to dismiss or basically throw out what the lawyers of Mustafa Hamid and the others were saying. Now, the presiding judge in the matter, Justice Francis Achibonga, indicated that, okay, the accused persons do not have this prior information regarding the notice of appeal against that High Court ruling, for which reason they are asking that the court stop the OSP from further prosecuting them. And so in light of this, the case will have to be adjourned until the determination of that challenge of the High Court ruling and essentially the stay of execution application filed by the Office of the Special Prosecutor. And so the case, Mustafa's case, has been adjourned to May 26th, about a month away, by which time they would know what's the situation as far as the stay of execution application and then the notice of appeal against the High Court's order. But Martin, we're going to see more of this because, for example, the case against the Buffer Stock CEO, Abdul Hanan Wahab and his wife, they are back in court tomorrow. And there's a likelihood that because it's also a case by the special prosecutor, the lawyers may probably want to pitch in the same thing, because basically what the High Court has been saying is that every case that is being prosecuted by the Office of the Special Prosecutor should, for now, stop until they seek authorization from the Attorney General.
We also, there were earlier reports from the court that the application that, or the argument made by the lawyers for Mustafa Hamid was earlier accepted. So those were earlier reports that we had heard, and that the OSP was challenging it. So following this decision, this particular issue in court, what was the reaction of the OSP? We saw that they had gone on Facebook to try and clarify and get the public to understand what exactly happened. What was the particular post of the OSP on Facebook about the issues regarding the responses from the offices of the Mustafa Hamid lawyers?
Right. So let me just take you through that. It says the High Court today refused an invitation to discharge the accused persons on grounds that the OSP has no prosecutorial powers, citing a High Court ruling dated 15th April 2026. The court noted the various ongoing proceedings relating to the OSP's prosecutorial mandate and adjourned the trial to 26th May 2026, by which time there may be greater clarity. Counsel for the accused argued that the OSP lacks prosecutorial authority to bring the charges. The OSP maintained that it possesses such authority under its enabling statutes, which are in force and operation and have not been repealed, amended, revoked, or struck down. Now, this sort of tells a different story from what happened in court, because, I mean, in as much as lawyers for Mustafa were praying the court or drew the court's attention of the fact that there's been a high court ruling barring the OSP from prosecuting matters, they actually indicated that looking at this, the case should be halted or stopped against their clients. But the OSP, in their write-up here, did not even indicate that they had indeed filed a notice of appeal and then a stay of execution application challenging the High Court's decision. If they had put that in their write-up, then it will put it into better context, because then with this info, it sort of like paints a different picture than what we saw happening in courts, because then it will be at a direct parallel or at the other side of what actually happened in court. So basically, if you're in court, you see that this is not really what happened. Because,
what happened?
Yeah.
Okay. Well, you would have to stay with us. We have another major court case that is of public interest. But let's listen to lawyer for Mustafa Hamid and the kind of argument they are making regarding whether or not they want the OSP, what they want the court to do regarding the fact that the OSP's authority is already being challenged. This is Akbar Khomeini, who is lawyer for Mustafa Hamid.
We are here to start case management.
Indeed.
And it was adjourned to continue today. But before today, we all heard the ruling of the General Jurisdiction 10 of the High Court, voiding the capacity of the OSP to continue criminal prosecutions in the absence of an authorization from the Attorney General. So when we got into court this morning, we raised an objection regarding the capacity of the OSP to continue with case management. Rightfully so, they opposed our objection, but the court, guided by its time-tested wisdom, decided that they would adjourn the case to 26th May, because the OSP indicated that they filed a stay of execution to that decision yesterday. So the judge said that he would adjourn the case to 26th May to await the outcome of the stay of execution. But he also indicated clearly to them that if the stay of execution application fails, he would proceed to enforce a judgment which voided the capacity of the OSP to continue criminal prosecution. So that's where we are with the NPA case, and we are happy with the decision of the court. We believe that it will serve the ends of justice at the end of the day. Well, we think it is a problem, because it is our expectation that as citizens, both natural and artificial citizens, that will be law-abiding. Once the High Court takes a decision, it doesn't matter how you feel about the decision. That decision is binding and ought to be respected. And indeed, for professional ethical reasons, we're expecting the OSP to announce to the court that the court should adjourn the case indefinitely pending the outcome. But they were insisting that they had capacity to continue with the case, and we objected strongly to that. So we would wait for the determination of their application for stay of execution, and then we will proceed with the NPA. If the appeal fails, it means that everything that they have done, right from investigation to prosecution, collapses. You know, we have the poison tree principle. Okay, so if you cannot build something on nothing. So if they do not have capacity to prosecute, it means every process that they have filed in this case collapses. But as I said, the court has adjourned to 26th May 2026 to await the outcome of the stay of execution.
Thank you.
And that is Akbar Khomeini, who is lawyer for Mustafa Hamid. So clearly, we are not out of the woods yet regarding this particular case. So we'll update you. Hopefully by that 26th May, we would all have a clearer picture of where this case is headed and what the authority of the special prosecutor is. We're staying in the courts, though, for our third major story, which is that the High Court has granted alleged 8 million Ghana cedi romance scam and wire fraud suspect Frederick Kumi, also known as Abu Trika, a bail of 30 million Ghana cedis with two sureties to be justified. Abutrika is challenging an extradition case against him and is currently in custody. Sani Abdul Salam is lawyer for Abutrika. Let's listen to Sani now.
The High Court granted the applicant for the appeals today, and as part of the conditions, we are to ensure that we get 2 sureties with 30 million Ghana cedis as part of the real conditions. So currently, that is what we are currently working on to see how best we can meet the orders of the real conditions. Still pending before the court, and in due time, we address the media with the details of the current steps we intend to take on that process.
So you had lawyer for Abutrika, Sani Abdul Salam. And so Abutrika primarily is currently on a bail of 30 million Ghana cedis. And it's because he is alleged to have been part of a romance scam and wire fraud amounting to the tune of $8 million. Let's step away from the courts now, and the minority in Parliament has asked President Mahama to publicly declare his position on the Office of the Special Prosecutor, stating that his earlier praise of the OSP appears to be mere deception in light of what they describe as ongoing attempts to undermine the office. The NPP members maintain that the recent High Court ruling cannot take away the prosecutorial powers of the OSP unless upheld by the Supreme Court. From 3rd December 2025 to the 15th of April 2026, the minority says it has observed a chronology of events which, in their view, point in one direction, that the government and its assigns intend to abolish the Office of the Special Prosecutor. We will be hearing from the minority as well as a member of the legal brain on the development first. But let's bring you some highlights of the OSP's response to the ongoing controversy surrounding his prosecutorial powers. You'd recall that the OSP has also been challenging this particular assertion and the decision of the High Court, which clearly ruled against the OSP, indicating that it does not have the authority to prosecute cases, a position that has largely been endorsed by the Attorney General's Department. Now let's go and listen to what the minority in Parliament have to say about this OSP debacle. Deputy Ranking Member on the Constitutional and Legal Affairs Committee, Alasan Tampuli, was the one that addressed the media and questioned what he described as a double standard being put forward by President John Dramani Mahama.
The High Court ruling must be immediately challenged and stayed, and we call on the OSP to immediately appeal the decision of the High Court and immediately also apply for a stay of execution at the High Court. And we dare also add that he must also proceed to the Supreme Court with a writ of certiorari to quash the decision of the High Court. We call on the Supreme Court to expedite its determination in Asiedu-Dartey versus the Attorney General. The Supreme Court question must be resolved definitely and authoritatively by the courts alone, by the court that alone has jurisdiction to resolve it. We call on the Honorable Chief Justice to treat this as a matter of great public importance, warranting urgent scheduling. The Attorney General must be summoned before Parliament to account for his position. It is constitutionally unacceptable for the state's chief legal officer to actively argue against a statutory institution of the Republic in judicial proceedings without parliamentary accountability. The minority will table appropriate questions and, if necessary, move for a formal parliamentary inquiry. We call on President Mahama to come clean with Ghanaians. He cannot continue to claim publicly that he supports the OSP while his own Attorney General argues for its constitutional destruction at the High Court and the Supreme Court. The President must choose, and he must choose publicly. Does he stand with the OSP, or he stands with the campaign to destroy the OSP? The fullness of time. The minority sets out the complete chronological sequence for the record of history and the judgments of the Ghanaian public. 3rd December, Martin Kpebu was detained and subsequently released. On 8th December, Majority Leader and Majority Chief Whip came by a private member's motion and bill to repeal the OSP. 10th to 11th December, President Mahama publicly rebukes and says that they must discontinue. 12th December, the very same day, the minority called for the resignation of the leaders of the majority bench. One Noah Adamte files a suit at the Supreme Court. 25th December to 1st January, a coordinated campaign of petitions were mounted against the OSP. On 26th January, Chief Justice Bafo-Boni determines that not a single petition had a prima facie value. 27th January, the Supreme Court dismisses the OSP's application to be joined as a party to the Adamte suit. On 8th April, Attorney General files submission at the Supreme Court siding with the plaintiff Adamte. 15th April, exactly 1 week later, the High Court grants a quo warranto to Peter Hyde and declares OSP's prosecutorial powers null and void. This is not a sequence of coincidence. It is a campaign, and the minority names it as such.
And Hassan Tampuli is the ranking member on the Legal Affairs and Constitutional Committee of Parliament. And so let's go to the phone lines now and speak to private legal practitioner, lawyer Christian Hesemam. A very good evening to you, sir. Unfortunately, we seem to have lost him on the line, but some of your messages have been coming in. I'll go through them quickly, then we can go on with this interview, which will most likely help us have a better appreciation of the subject. Aaron Babaku Kokomisa, who is listening to us on Facebook, says, "Good evening to you. If the Office of the Special Prosecutor lacks independent authority to prosecute criminal cases, meaning all such matters must now be referred to the Attorney General's Department, then my single question is, what then properly defines the OSP? I am not in a position to challenge the High Court ruling. However, the OSP was established to investigate and prosecute corruption to ensure proper accountability. If the High Court has ruled as such, we will expect to see more work from the OSP to sanitize the system." And that's a message coming in from Aaron Babako Kokomesa on Facebook. Also, another message here coming in from Araba SL from YouTube. She says, "Sometimes I get sad about how the court system drags, but they say the wheels of justice grind slowly. So yeah, I hope all these cases are heard and brought to a finalization. If Wontumi is found guilty, the law must take its course." So your messages are always welcome. Thank you for sending these through. Again, Facebook and YouTube, we are streaming live, so your comments, when they do come in, we'll definitely share it with the rest of the world. Let's go to the phone lines now. Hopefully we have private legal practitioner Christian Hesemam joining us. Mr. Mam, if you can hear me, good evening. Thank you for your time.
Good evening, and thanks for having me, my brother.
Right. What's your, first of all, your general assessment of this back and forth as to whether or not the OSP has authorization to prosecute cases? Is this something you had already thought of, or you are also now, looking at it differently and like, we seem to have sidestepped what Parliament should have done much, much earlier?
Thanks so much for mentioning the last institution, the last word, Parliament. You see, in legal theory and jurisprudence, we have what Professor Hart described as the rule of recognition. Now, the rule of recognition forms the secondary rules that the law traces to be the primordial law, where the institution has been given that legal mandate in order to promulgate laws to cure the primary rules. Now, what am I saying? What I'm basically saying is that in the primary rule, there are laws which the masses form for themselves, but those laws are uncertain. In order to cure the certainty, that is how come the secondary rules are created, and this defines the legal system. And what is happening so far, tracing it from legal theory and jurisprudence and juxtaposing it to what is currently happening, is at the heart of the rule of recognition, which is Parliament. And Parliament went through all of this. Now, this is not a private member's bill where you would say that, okay, it was sponsored. This emanated from government. So the executive arm, and then it went to the legislature. It went through all the readings, the committee review, and all of that. It stands to say that this has created an uncertainty of the law. And the question that actors ought to ask themselves is, what is happening to our rule of recognition? It's a very big question. Now, to further simplify the point, authorization, as you mentioned, is one that Section 4.2 of the OSP Act has prescribed. And indeed, that makes it subject to, or it is a subjugated provision to Article 88. Article 88(2)(3). And if you look at the object and the framework which it works in, it affects it, Section 3 thereof, it affects it with both investigative and prosecutorial. Investigative, no problem. But with the prosecutorial part, it says that it is subject to authorization. Now, the question here again is the meaning of authorization a technical word? And that question is not, because the point is that if we are looking or we are dealing with construction of statutory provisions, Apalu in Salah and AG indicated to us that we need to look at the provision in whole, where we are still not understanding it, or the word in quite ambulatory, or the text is not matching up to it, then, or creating uncertainty. We look at the ordinary natural meaning. Now, it is easy for us to infer from the ordinary natural meaning to say that the provision does not infer anything of controversy. But the point arises where we now need to match it up to, or in applying it to, or running it by Article 88(2) and 3. And then the issue of subjugation comes in. That is the OSP subject to approval, or must the OSP get a fiat, approval, whatever, leave, as we know the lawyers normally say in court, before it can proceed? If the provision places emphasis on authorization, which is not ambiguous, running it vis-a-vis by the Constitution, then we say that the expression by the High Court would be that it only engaged in the jurisdiction of applying the statutory interpretation vis-a-vis the Constitution, and that it did not necessarily engage in enforcement and interpretation. Now, if it is believed otherwise, and it is the reason why there could be a recourse to the Supreme Court, that the learned judge sitting at the High Court engaged in enforcement, contrary to what had been said by ex-party Ajiman Rollins, Dr. Zenator Rollins, where Justice Atuguba indicated that when it comes to construction of constitution, the High Court is not vested with that power, but it can. The High Court at all times engages in limited role when it comes to constitutional interpretation. I've heard some lawyers say that the High Court does not have jurisdiction simpliciter. Even on this platform, I've had to intervene to correct that erroneous impression, because the High Court indeed has that limited interpretation powers. Other than that, the Supreme Court will be inundated with a lot of construction matters. That's why in the case of Republic v. Maikankan 1971, the High Court had to come up with a litmus test on what cases or which cases could be referred to the Supreme Court. And it was further refined by Justice Atuguba, where he emphasized the principle of it must be application versus interpretation. So in this situation, having said this, the next point we also to look at is, just as I have said, if it is one that the court has exceeded its powers, what will avail would be certiorari, which would be that certiorari comes in where there's infringement against natural justice and excess in terms of jurisdiction. And this one goes into matters of excess in terms of jurisdiction. And where that situation is, then the Supreme Court will hear it in order to quash it. But if it is one where it goes even to the Supreme Court, and the Supreme Court is of the opinion that it was an application of Article 88, then nothing of that sort would arise. Then the resolution would be that if indeed we want to correct this in the secondary rule, then Article 88 ought to be amended in order for the OSP to have that independence, to have prosecutorial, and not have it from any other parallel or superstructure to direct it in terms of permission before it can carry its mandate. Okay. And that would mean that Parliament, as we have vested and created in the rule of recognition, is functioning to its fit.
It means also then that, like you're suggesting, or like some other legal, individuals have proposed, we will have to properly look at Article 88, and then if there is a need for a review, we do that immediately because, like the saying goes, or which has become a cliche now, the law is the law. And on the surface of it, it looks as though the full authority to prosecute is in the bosom of the Attorney General. So if a parallel or another institution like the OSP's office also needs to or wants to prosecute, it will need that authorization from the Attorney General's office. This clearly is a legal matter, not politics. What do you make of the fact that politicians
the president can do little about it?
The call by the minority
can do little about it.
That the president should clarify himself.
What troubles me is how frequently it is becoming, and I'm writing an article on it, which is more in jurisprudence and legal theory, because if we are having Parliament coming up with laws, and in the shortest time, instead of creating certainty, it rather turns out to create uncertainty, then it should be a worry for us as a state. It is because Parliament is sitting in the rule of recognition in order to define the legal system of the state. So that if you look at the mining laws, the same thing happens. Mining at certain areas where the boundary and all of that discretion is given. And in just a short time, the nation had to cry because the laws emanate from the people. And then there was a hue and cry amendment. The same thing is happening with the OS because we have rallied behind the flag against corruption and corruption-related matters. So the cry tells us that irrespective of who is occupying the OSP's office, Ghana has moved to a state where it is no longer ready to subordinate itself to corruption, but wants to have the anti-corruption fight stand on its own, and whatever laws Parliament are coming out with, that laws must stand the test of time. It shouldn't be that when a law is put out in order to cure a primary law which is uncertain, it rather comes to cause more further uncertainty. When that happens, it affects the certainty of the law, and it's not good for the legal system.
We are grateful for your time as always, Mr. Hezima.
Thank you for having me, sir.
And he's a private legal practitioner helping us have a better appreciation of what all of this means, whether or not the OSP can prosecute. That actually, on the face of what the High Court said, that has been determined. Based on what the High Court said, the OSP cannot prosecute cases. If the OSP wants to prosecute any case, they need the authorization from the Office of the Attorney General. However, this particular issue of the authority of the OSP is also at the Supreme Court. So we are waiting to see what all of this will mean going forward. And a number of cases that are all hinged on this particular decision are also in the offing. So it means that the final decision and the interpretation that the Supreme Court will give would have a certain impact on the current cases also being prosecuted or being undertaken by the OSP, which is in court. Would update you when we do get any new developments regarding that. Mind you, a coalition of 12 civil society organizations have also joined the fray and are asking for an intervention, saying that the authority of the special prosecutor is set in law and cannot be waived. They warn that a high court order on how the OSP can exercise its prosecutorial powers could unravel 2 decades of anti-corruption progress and provide accused individuals with a ready means of escape. The CSOs firmly dispute the constitutional argument being advanced by the Attorney General in the Supreme Court proceedings. Let's listen to Dr. Kojo Pumpuni Asante, who is the Director of Public Engagement and Partnerships at CDD Ghana.
This is not the only statute that seeks to confer prosecutorial powers on other people outside of the AG. And if you make that argument, then it means that even in the future, if an AG comes and says they want to delegate their power, and Article 88.4 is very clear, you have to do it in accordance with law. You are saying that they cannot do it through a statute. The disruption can be extremely terrible. You can just imagine if people had reached out to the AG that, they were prepared to even do plea bargaining or make a confession. Now they've been given a way out through these actions. So I think it does not inure to the benefit of the public in any way. So hopefully the Supreme Court can bring some clarity to it, and then we know where we move from there. But what has happened obviously is not good for the Republic and not good for the citizens. If we were even worried about legality issues, we have the constitutional review process to resolve it. So what's the hurry? What's the rush?
Kojo Pumpuni Asante is a director in charge of public engagement with CDD Ghana. He is also the director of public engagement and partnerships, Dr. Kojo Pumpuni Asante. There. Let's step away from legal matters now, and tension is mounting on the Minister for Lands and Natural Resources, Ama Kofi-Boa, to terminate the mining contract awarded to Heath Goldfields to operate the Bogoso Prestia mines. Employees of the company, led by their counsel, Martin Pebo, addressing journalists in Accra, accused Heath Goldfields of contractual breaches, including lacking the financial capacity to manage the mines. Here's a report by Stanley Blue.
The Bogoso Prestia mine was awarded to Heath Goldfields Limited through a competitive tender process on December 13, 2024. Per the terms of the agreement, Heath Goldfields Limited was expected to inject a total of $500 million into the company over a 5-year period, while fulfilling additional obligations, including the settlement of employees' entitlements within 7 days of taking over the mines. The company was also required to install crushers and $2 million worth of water pumps to drain accumulated underground water from the shafts. These measures were scheduled to be executed within phase 1 of the contract period, spanning 2025, but the group insists those obligations have been breached. Addressing journalists, counsel for the employees Martin Pebu said that out of the $150 million expected to be injected in the first phase, only $23.7 million has been made available.
If we haven't said anything at all, what we're saying is that by now, $150 million must have been sunk. So once the $150 million has not been sunk, it means that we are seriously in the realm of what? A breach And look, to be clear, we are very reasonable people. If they had sunk in 100 million by this time, no, you wouldn't have seen me here. I don't do that. I understand businesses face challenge, etc. I wouldn't have been here with them. But where we are 23.7 million, which is even far short of the 50 million that was required to have been released in December 2024.
He added that disclosures made by Heath Goldfields prior to the award of the contracts were fraught with inconsistencies and called on the government to terminate the agreement.
For the sake of the Prestea Union Valley communities, national revenue, and the integrity of Ghana's mining sector, we respectfully urge the Honorable Minister to exercise his powers under Section 68 of the Minerals and Mining Act 2006 Act 703, to terminate Heath Goldfields mining leases.
And you hear the voice of Martin Kpebu, who is lead counsel for the employees of the Prestea Mining Company. They are asking for the Minister for Lands and Natural Resources to terminate the mining contract of Heath Goldfields. In the coming days, we'll update you on what the next line of action will be. This is 3FM 92.7. You're listening to Hot Edition. Time now for sports.
Hello, good evening, and welcome to the sports segment here on Hot Edition on 3FM 92.7. My name is Uri Kwampofo, and we start off from the Premier League, where Nottingham Forest winger Callum Hudson-Odoi has been ruled out for the rest of the season after successfully undergoing surgery on a quad injury that he picked up in their quarterfinal game against Porto. Now, the catch for Ghana is that in the previous weeks, Ghana had been engaging the winger on the possibility of switching his allegiance to the Black Stars ahead of the World Cup, but that has been put to bed as Hudson-Odoi is expected to be out for months and should return ahead of the 2026-2027 season. There's also Premier League action later tonight where Chelsea and Brighton would be battling out in a game which would have large significance for the sixth slot in the Premier League as things do stand. Currently, it's Chelsea who occupies sixth with 48 points ahead of Brighton, who are in ninth with 47 points. And so Brighton know that a win tonight would take them above Chelsea into sixth in the Premier League. Lineups have already been released ahead of the game, and the big story is that Cole Palmer doesn't start in the game against Brighton, as he isn't in the squad to face Brighton. And so it's a front three of Enzo Fernandez, Delap, and then Pedro Neto as well. We'll be bringing you updates of this match and more on our social media handles at 3SportsGH. My name is Uri Kwampofo, and that's how we'll be wrapping up Hot Edition here on 3FM 92.7. We'll be back same time tomorrow.